canceled across all sectors. Many schools, colleges, and universities have closed, and we know that this affects foreign students who may face challenges obtaining their practical training or completing the terms to be in the terms of their visas to remain in status. And so all of these changes are having a significant impact on foreign workers, visitors, and students whose visa classifications are being limited because they're not able to engage in the activities that they otherwise would need to participate in. Let's see. Hey, Claudia, I think I'm not able to change the slide. I'm not sure if, there we go. Okay, so then we look to, okay, so what is the operational impact of immigration that COVID-19 is having? So on March 20th, we know that the department, it's actually the Department of State, announced agreements with Canada and Mexico to restrict unnecessary travel across our land borders. And each of these agreements went into effect on March 21st for 30 days, which is also subject to change, I'm sure. And so these agreements have eliminated unnecessary travel. And so this includes travel for tourism or recreation. We know that trade continues, and in some circumstances, folks are able to travel if they commute across borders for work. Let's see. And then any other essential or whatever the government is, whatever it is that the government is deeming essential travel will continue. Can I get the next slide? Thank you. Okay. And so effective March 18th, and it says on the slide through April 1st, but this has been changed through April 7th. USCIS has suspended in-person services at their field offices, at their asylum offices, and at the application support centers. And so, you know, we anticipate that this is going to cause delay for individuals who are awaiting benefits to be adjudicated that require interviews, or for folks who are not able to complete their biometrics, which is necessary for adjudication of their benefits. ASC appointments, we know, will automatically be rescheduled, so folks will be notified when they can go ahead and complete their fingerprinting for their applications. However, InfoPass appointments are going to have to be rescheduled by the applicants through the USCIS contact center, and that's once these offices are reopened and once USCIS resumes these services to the public. And we also know that USCIS is providing limited emergency services, and so if you are in a situation that you think merits a designation of an emergency service, then go ahead and contact the USCIS contact center, and an officer will assess whether or not your needs constitute those that exception for emergency services. CIS has not announced that it's going to close its service centers where most applications are being adjudicated, and so we know that benefits are still being processed and applications are being reviewed for the time being. Okay, next slide. Thank you. Okay, and so the Department of Justice manages our immigration courts under the Executive Office for Immigration Review. We know that all non-detained and MPP hearings are that were scheduled through April 10th, 2020 have been postponed. There are hearings that are taking place for the detained docket, and so detained cases are going forward. However, we strongly recommend that anyone who whose relatives may have a case pending, or who is not sure about whether or not their case has been rescheduled or may be going forward, to contact the UIR customer service phone number and listen to the recording regarding the specific case in question. We know that all filings due during the court closures are actually to be filed by today. So March 30th is the designated deadline for filings for any filing deadlines that are taking place during the closure. And then if anyone has any doubt or any question about whether or not their specific, or the specific immigration court handling their case is open, we're going to direct them to the EOIR's Twitter page and the EOIR's website, their main page, there is a posting that indicates which courts are continuing to hear cases during the coronavirus pandemic and the closures. Okay, next slide. Yeah, okay. And so then the next question is, what about enforcement? So is there enforcement that's going on during COVID-19? And the answer is yes. However, let's see. So ICE is Immigration, Customs and Enforcement, and that's the enforcement branch of the Department of Homeland Security. And they have announced that they're temporarily changing their enforcement policies as of March 18th. And so enforcement and removal operations are now going to focus on individuals who are deemed public safety or national security risks, as well as those who are subject to mandatory detention based on criminal grounds. Criminal investigations will continue, and ICE has said that they will not conduct enforcement operations at or near healthcare facilities except in extraordinary circumstances. All this to say is, we know that ICE is, in the field, and operations are still continuing. And despite these announced changes in policy prioritization, it's important for anyone who could potentially confront ICE to know what their rights are. And so that's really why we're here today, is to offer some insight as to what those rights are. And so if we move on to the next slide. And the next one, here we go. Okay, so what is someone's right what are someone's rights when coming into contact with an immigration officer? The most important right for everyone to know is that you have the right to remain silent. You do not have to give an ICE officer any information at all. However, if you do determine or decide that you will cooperate with ICE or offer information, it's important that that information not be false or misleading. You're not obligated to answer any questions, including place of birth or immigration status. And we emphasize very strongly that it's important not to show any kind of false documentation. We know that there are many undocumented folks who they need to work, and they may have an EAD or an employment authorization document that is not issued by the Department of Homeland Security. Those kinds of documents should not be carried by folks, or they shouldn't have those on hand because of the risk of coming into contact with ICE. If that kind of document is on their person and somehow ICE has access to that document, it can have very negative consequences going forward. Also, if someone does ultimately find themselves in ICE custody, it's important that they insist on their right to contact their attorney. It's critical that they have an opportunity to contact their attorney, because in the process of being apprehended by ICE, they're going to be given many documents. They're going to be asked for signatures. They're going to be overwhelmed with the scenario or with the circumstance. And so they should be able to contact someone who can help navigate them through that process. However, in the event that someone is not able to access an attorney, and they're in custody and they're being asked to sign documents, they do not have to sign any document that they cannot read or that they do not understand, or that is not in a language that they can read or understand. And so someone has the right to deny or to refuse to sign documents handed to them by ICE officers. Oftentimes, ICE agents are present on work, in the workplace or on the premises of one's employment. And so in those situations, it's important to be alert. It's important to keep an eye out for any government vehicles. If you notice a government vehicle, then look to see if there is law enforcement around. Be proactive, alert management or human resources that ICE is on the premises, and inquire about the nature of their visit. Do not provide any information or the location of any employee if they inquire. And something that we stress is that if you see an ICE officer and an ICE officer can see you, do not run from that officer, because they will follow the person and likely apprehend. So it's important to remain calm and collected, as to the extent possible, in the event that an ICE officer or several officers are present at the workplace. And then also be prepared. So if human resources is not at the workplace, have that contact information on hand, and also have an immigration attorney's contact information on hand as well. And what about if a police officer or an ICE agent comes to the home? This happens a lot. And what's important to know is you do not have to open your door to any officer unless they have a search warrant or an arrest warrant is presented. And not only do they have the warrant, but that the warrant is a valid document. And so how do we know, how could anyone know whether or not an arrest warrant or a search warrant is a valid document? So things to look for. The person, you know, if it's an arrest warrant, then it must include the person's name, who they are there to arrest. It also should include their correct address, and it has to be signed by a judge. So if the document does not have a person's specific name or address and is not signed by a judge, that is not a valid document. It's not a valid warrant to access or to give access to the officers who might be knocking on the door. And a search warrant must also include the address of the place to be searched and also be signed by a judge. And so if it's not signed, then again, it's not a valid document that should warrant access to the officers that are knocking on the door. And then another important thing to be aware of are sneaky tactics that ICE might engage in to gain access to a home. And so a very common occurrence is that an ICE officer knocks on the door and has a picture belonging to someone that the person opening the door would definitely not recognize. The ICE officer would then inform that person that they are searching for the person in the photo and ask for access to the home to see whether or not that person is in the home. And essentially that's a tactic to get the resident of the home to let their guard down, because if someone is showing you a photo of someone you don't recognize, likely you're going to feel that ICE is not there for you or anyone in the home, and so they should, you know, no big deal, okay, come on in, take a look around. And then once the ICE officer gains access to the property, at that point then they will likely arrest anyone who's in the home that cannot show evidence of legal status, and it becomes an awful experience for anyone in the home. So that is something that they often do, and so we strongly advise, regardless of whether or not they're showing a photo of someone who you know does definitely not live in the home, do not offer that access. And then we have, in the interest of time, I'm going to kind of breeze through these, but you will be given the materials and copies of the PowerPoint presentation. And so we do have this example here of a district court search and seizure warrant. And so you can look at that as a reference. And then on the next slide, we have, let's see. And then, okay, on the next slide, then we have an example of a warrant for arrest of an alien that's issued by the U.S. Department of Homeland Security. And so the important things to just note there are, again, the signature by an authorized officer at the bottom, and then also where you see there's going to be these redacted sections, which would include the name of the person who the warrant pertains to. And then on the next slide. Okay, so what happens? What do we do if someone we know is arrested or detained by an ICE officer? And so the first thing, you know, that one should do is contact an immigration attorney. And so we have clients who have our card on their refrigerator, or maybe not ours, but the card of their immigration attorney on the refrigerator, and everyone is aware that if, you know, someone in the household encounters ICE or is detained by ICE, then they need to call the attorney on that card. The person who is apprehended will be, if they don't already have an alien registration number, they will be issued one. And so that number is going to be very important for tracking them while they're in custody, and also for tracking just the progress of their case. And so the alien registration number usually starts with the letter A and is followed by 8 or 9 digits. And then they may also be given a booking number. And so that booking number is also important to get from that family member or that friend that's in custody. And then they should make note of any documents that they receive from immigration and be able to tell their attorney or their family members, if they can't speak, if they haven't had an opportunity to speak to their attorney, what those documents are. Again, if someone is in custody, it's important for them to know they do not have to disclose their immigration status, and they do not have to disclose their place of birth, even if asked by immigration or ICE. Okay, and so what are some things that, that people can do, or that we can do, just sort of in, anticipation of a possible worst case scenario? Preparation. It cannot be emphasized enough that it's important for all folks who, are either not in status or who are anticipating to apply for a benefit to have the proper documents in order or in place. Let's go back one slide. Yeah, to have the proper documents in place, because typically these documents are applicable across the board when it comes to applying for immigration benefits or when applying for applications defensively in immigration court. And so these documents, actually what we advise is that these documents be kept in sort of like a file box or in a dossier somewhere that's accessible to other family members, and that trusted household members know where to access them. And so those include passports, expired or current passports, birth certificates, marriage certificates, bank statements, tax returns, and paycheck stubs. And these are not necessarily recent bank statements, tax returns, and paycheck stubs. Oftentimes folks are required to show a continuous physical presence in the United States, and these are the best types of documents to establish physical presence. And so we say, don't ever throw these away, just keep them. I mean, despite any kind of advice from accountants or folks that you can, get rid of documents after 7 years or 10 years, go ahead and purge them. When it comes to immigration applications, we say, do not throw them away, keep them as long as you can, because those documents will serve the purpose of establishing continuous physical presence if necessary. And so don't throw those documents away. Also, medical records, IEP reports, report cards and certificates like of merit belonging to anyone in the household or in the family are documents to hold on to. Immigration documents, so if there's ever been an application previously submitted on one's behalf, receipt notices, work permits, green cards, all of those documents or copies of those documents should be kept in that dossier or in that file box. Copies of government identification, and so that's not just, in the specific state that the person's living in or that members of the household are living in, but if they have consular identification cards from the home country or country of nationality, then we advise that copies of those documents, so foreign identification issued by governments abroad, also are documents that you want to have in that box of documents. Social security cards and ITIN numbers should be kept in there, as well as emergency numbers and important contact information. Also, if there are any restraining orders in place, or if there have been restraining orders in place, divorce decrees, custody documents, or any other kind of court document should also be included in that dossier or document box. And then another thing to consider is, if someone owns property or has a business, you should consider having a power of attorney that affords the legal decision-making power to someone that you trust, so that in the event that you should have to sell property or conduct business, or that they would have to sell property or conduct business on one's behalf, they're able to do so through the power afforded to them by that legal document. And then we'll talk about kids. We'll go ahead and switch to the next slide as we talk about considerations for guardianship and protecting one's children. Okay, so it's important for, it's important to have a child care plan in place regardless of one's immigration status, I think. So in the event that, we've seen or we've heard the reports, the awful news coverage of a family in which the parents, or maybe one parent, was apprehended by ICE and the children were at school, and because there was not a child care plan in place or an emergency contact on file, the school then handed those kids over to the foster system, and so, or child protective services. And so this is something that, you know, is devastating all around for everyone involved and everyone in the family. And so to the extent that you could limit the trauma that a child would experience should they have a parent who may become subject to immigration custody, then by having a childcare plan in place, you could do so. And so what does this mean? It means that you could prepare a caregiver's affidavit of authorization. That's the document in California, but I'm sure every state has an equivalent. And so just a document that affords, you know, custody or the right to take the children into one's care so that they're not handed over to child protective services, so that they're, you know, released to someone that's trusted, to another relative, to someone that is close to the family. And then also you could explore guardianship, the actual legal guardianship of someone who is close to the family or a relative, so that the kids, there's no interruption in the kids being sort of handed off to that person should their parent become apprehended by ICE. And also make sure that the emergency contact information at the school is updated and that the school is informed and aware of who they are able to release those children to in the event that their parents do not arrive to pick them up one day. It would be wise to create an important document file for the child. And so a lot of the documents we previously discussed on the page listing all the documents for the dossier would also apply for the children, right? So then copies of all the children's documents, you know, emergency contact information, medical records, IEP records, if they have a school ID, those kinds of things would be important to have in that document file for the child. And then to the extent that a parent feels comfortable doing so, it might be a good idea to talk to the child about a potential plan so that, you know, in the event that the person's parent or that the parents become detained by ICE, the child knows exactly, you know, what you talked about. They know what's going on. It's not a complete shock to them, and they're able to, I mean, to the extent possible, they're able to adjust to whatever the new sort of circumstances become or the new reality becomes for them while their parents are navigating through their immigration, through the immigration system and trying to get released from custody. And then another thing that some consulates, I'm not sure that all of them do, but I know specifically the Mexican consulate permits folks to register their children with the consulate. So any Mexican national can register their child regardless of whether or not the child was born in the United States. Okay, and so then with that, we'll transition to immigration fraud. Immigration fraud is a huge problem. There, unfortunately, are many people who represent themselves as attorneys or notarios or immigration experts or immigration consultants who are not actually licensed to practice law or who are not BIA accredited representatives and who do not know the intricacies of a very complex immigration system that we have here in the United States. And then as a result, the folks who rely on their services find themselves in very precarious situations and possibly in immigration court or possibly may have deportation orders in place without even knowing it. And so we highly, highly recommend that anyone who is seeking assistance with an immigration process, which whether it be applying for benefits, and especially if they may have a case in immigration court, that they work with an attorney, a licensed attorney, an attorney who they have been able to confirm with the state bar, whether it be in California or any other state, but you can confirm that they're licensed with the state bar. And if not an attorney, then someone who is a BIA accredited representative. It's important to do so because you want to be able to hold them accountable if they do engage in any kind of misconduct in handling your case or representing you. And so some things that are sort of red flags that we encourage people to maybe walk away from that process is if the person representing them asks them to just sign a blank document. They give them an application and it's completely blank but for maybe their name, and they say, go ahead and sign this and I'll fill it out and send it in on your behalf. This is a big no-no, because anyone who is submitting documents to immigration has to be, immigration will hold them accountable for whatever's submitted on their behalf. And so if you sign something without knowing what the document contains or what information it contains, then that could be a problem. We've seen several cases in which people people signed documents that ended up being applications for asylum, and they were citizens and nationals of Mexico, yet this immigration expert or consultant represented them as being from Central America so that they could take advantage of an application that was available to Central Americans at a specific time. And so now immigration has them listed in their system as being from Central America. Well, this is a huge problem. And while there may be resolution for this, for these types of cases and for these individuals, it's a headache and it's very stressful. And so to avoid these types of headaches from the outset, it's important to make sure that you're not signing any blank documents and that you're reviewing the content of an application before it's submitted on your behalf. If you need to bring someone with you to help translate the document, I mean, presumably the office would have a translator, but do whatever you need to make sure that you know what information is being submitted. And always ask for a written contract. A written contract is important because should you need to file a claim against someone with the state bar or with the Fair Trade Commission or with an Attorney General's office, you can show that you had a contract and that the person representing you was in breach. And it's also just a paper trail. It's a way for the agencies to track this individual who has engaged in fraudulent services. Always request copies of any written documents submitted on your behalf. So any applications that someone submits to USCIS on your behalf or to the court, you are entitled to copies of those documents. Those documents are considered your property, and so you can request copies of any applications. And then always request your originals. Do not leave your original birth certificates, marriage licenses, passports at your attorney's office. It's not necessary because those documents are not submitted in their original form to immigration. Only copies are submitted. And so be sure to take your originals with you to avoid anything happening to them or to avoid them being misplaced or to avoid them being held, as a method of retrieving payment. Sometimes we've heard stories of folks refusing to submit or refusing to return someone's original documents to them unless they pay more money. And so to avoid these kinds of situations, then it's important that you just from the very beginning make sure that you either give copies of those documents to whoever is assisting you, or you request that they make copies and return your originals to you. Okay. And again, so if you have been a victim of fraud, you suspect it, or you know that you've been a victim of fraud, then you can report this. In California, you can report it to the State Bar of California, and the phone number is listed, 800-843-9053. You can also, if the person who has committed the fraud is not an attorney, you can also call the Attorney General's office. And then also you can report this fraud to the Federal Trade Commission as well. Okay, and so now we transition to the public charge rule that has recently been changed. So it was initially to go into effect October 15th of last year. However, due to an injunction, it was postponed and recently went into effect on February 24th, 2020. Let's see. So an important thing to know about the public charge rule is that USCIS has announced that any foreign national who undergoes testing or treatment for COVID-19 will not be negatively impacted under the new public charge assessment. So it's very important because, the last thing that should be happening is that there be a chilling effect on people and preventing them from seeking testing or treatment during such a just horrific pandemic because they're afraid that they may not be able to apply for their green card, or they're afraid that an application for a green card might be negatively impacted by a public charge finding. But that said, the agency has not otherwise deferred the public charge assessment. So although someone who requests or who obtains treatment or undergoes treatment for COVID-19, folks who, you know, and we'll talk about this in more detail, but folks who otherwise are obtaining any public benefits or medical treatment may be subject to the public charge test or an assessment. Okay, so what is inadmissibility on the basis of public charge? And so under the former rule, an immigration officer would determine whether or not someone was likely to become primarily dependent on public benefits, meaning that they would rely on public benefits for 50% or more of their sustenance. That was pre-February 24th, 2020. And so now an immigration officer will determine whether or not whether or not an applicant for a visa, a green card, or a visa or green card in the United States may receive one or more public benefits for more than 12 months in the aggregate within a 36-month period. So what does that mean? So it means that someone who is receiving public benefits, let's say, for example, someone is receiving 3 separate types of benefits. Let's say they're receiving food stamps, they're receiving public assistance or public housing assistance or Section 8 housing, and they're receiving treatment under Medi-Cal. So it's 3 separate benefits. And let's say the person, you know, may be in need of those benefits for 3 months. Well, under this test, under this new public charge test, the officer is not going to consider that the person will only have needed 3 months of benefits. In fact, in the aggregate, they're going to look at each program and then consider the period of time that that program was necessary. So if each program was necessary for 3 months, then we're looking at a 9-month period in the aggregate. And so it's a much more difficult, well, it's a much broader test now. And again, that's within a 36-month period. And so for this reason, it is strongly recommended that anyone who's planning to file for adjustment of status in the United States or an immigrant visa at their consulate abroad, that they really do consult with, an immigration attorney to determine whether or not they might be affected by the new public charge rule, because it's a balancing test. It's not a clear-cut rule. It sort of requires the officer to play or to engage in a little bit of clairvoyance and fortune telling, to the extent that they're determining whether or not the person who's applying for the benefit will need public benefits or public assistance in the future. Okay, and so how is public charge determined? So the new criteria shifts the focus from the petitioner or sponsor and redirects it to the applicant by conducting a balancing test of factors. And so every applicant, the officer is going to consider for every applicant their age. And so we know that anyone who is applying for a green card in the United States or an immigrant visa abroad, and even a non-immigrant visa abroad, if they're not of working age, so if they're under 18 or they're over the age of 65, this is going to be something that counts negatively against them. They're going to look at their health and history of health. And so if the applicant has some kind of health condition that's chronic, this is something else that would be counted against them negatively. Family status, so the number of household members and whether or not any of those family members are relying on public benefits, even though that will not automatically disqualify someone, or even though that will not automatically trigger a finding of inadmissibility, it's something that will be considered in this balancing test. The officers will be considering financial status of the applicant and whether or not they have any assets or resources. They're also going to be looking to their education or level of education and whether or not they have any special training or skills. And they're also going to be inquiring as to whether or not the person has received any public benefits in the past and what they were and why they were needed and for how long. So the new public charge test is making it very difficult for applicants who are elderly, disabled, who may have low income or limited skills or limited education to overcome a public charge finding. And so there's a lot of confusion though. I mean, what is, who is subject to the public charge test? Lawful permanent residents who are seeking citizenship? No. Folks who have, who are, renewing DACA, who are renewing TPS? No. So let's look at who will be affected. So we're talking about here applicants who are applying specifically for a green card through adjustment of status, applicants applying for visas abroad, including the immigrant visa, which permits them to travel to the United States and then become lawful permanent residents upon entry. And then also folks who are applying for non-immigrant visas as well. Applicants who are applying for change of status within the United States may be subject to this test. And then also, so lawful permanent residents generally are not subject to the public charge test unless they have traveled abroad and they are returning to the United States and they have criminal convictions, or unless they have traveled abroad and they are returning to the United States after having been absent for a period of 180 consecutive days or more. So these, just to stress, so these are the folks who specifically are going to be impacted by this change in the public charge test. Again, just to reiterate, so it's folks applying for green cards in the United States, folks applying for an immigrant visa to become lawful permanent residents upon arriving to the United States, folks applying for a change of status within the United States, folks applying for non-immigrant visas abroad, and then also in limited circumstances, lawful permanent residents who have traveled and who are returning to the United States and may have criminal convictions or have been abroad for 180 consecutive days or more. And who will not be affected? So US citizens and individuals applying for citizenship will not be affected. However, we know that even though there's not a public charge test when applying for citizenship, an officer may inquire about receipt of any public benefits to determine if the person qualified at the time that they receive them. Lawful permanent residents renewing their green cards or applying to lift the conditions from their LPR status will not be impacted. US citizen children under 21 and pregnant women who are applying for Medi-Cal or Medicaid connected with their pregnancy and who receive services for up to 60 days after pregnancy will not be impacted. Individuals applying for who have been granted status through programs such as asylum or refugee status, U visa, T visa, VAWA, and special immigrant juvenile status are not impacted by this change or are not impacted by this public charge rule. And individuals renewing TPS or DACA are also not impacted. Permanent residents or US citizens petitioning for family members are also not impacted. So only the family member, only the person who's applying, only their applications, only their receipt of benefits can be counted against them. So if someone's being petitioned by a US citizen or a lawful permanent resident who has received some kind of public benefit, this is not something that should be counted against the applicant. However, that being said, we know that in that balancing test, family status is something to be considered. And so the officer will be looking at the household size and whether or not anyone in the household has received benefits in conducting that balancing test. Okay, and so the question that we often are asked now is, well, are there any government programs that are still safe to use? And so the answer is yes. And these are school-based services or benefits. So for example, reduced lunch or free lunch programs and Head Start. These programs should not negatively impact someone under the public charge test. Emergency Medicaid and in California, emergency Medi-Cal. And then this also includes state-funded medical assistance. So for example, clinics who have received state funding to provide services for low-income patients, these kinds of services also will not negatively impact the applicant under the new public charge test. Children's health insurance program also will not be impacted or will not negatively affect someone. The AIDS drug assistance program will not negatively affect, And services provided under the Individual with Disabilities Education Act will not be negatively impacted, or will not negatively impact the applicant. Also benefits for women during pregnancy and during the 60-day period after pregnancy. And so this would include WIC. And then also disaster relief will not negatively impact the person. And so in the event that someone is maybe might apply for DSNAP, so food assistance that is, that is offered through an act specifically to address disaster relief, that should not negatively impact the applicant. Okay, and then let's see. Another question that we've been getting a lot lately, given the effect that COVID-19 has had on employers, is whether or not someone who is not a lawful permanent resident or not a citizen can apply for unemployment insurance benefits. And so we know that to collect unemployment insurance benefits, the applicant must show that they were authorized to work in the United States when earning the wages used to establish the claim. So what this means is that the applicant must have had a work authorization document in order to be able to apply for unemployment. They must show proof that they are currently authorized to work for each week that they claim unemployment benefits. And we know that, so specifically to California, the individuals can apply for unemployment through the EDD website, and I've listed the link here. And the EDD is going to verify that person's immigration status or work authorization through the Department of Homeland Security directly. And so if the person is not a lawful permanent resident and not a citizen, but does have authorization for employment, then they had authorization for employment during the time that they're requesting that this claim be based on, and then they continue to have authorization for employment, then they should be able to obtain those unemployment benefits. Okay. Let's see. Sorry that I'm losing a little bit of control over the PowerPoint, but I think we're good now. Okay, so receipt of public benefits generally. So under the old rule, an applicant who had received any of the public benefits described below for more than 12 months in the aggregate of a 36-month period could be found inadmissible in public charge. And so, under the old rule, the benefits that were considered were supplemental security income, or SSI, temporary assistance to needy families, or TANF, and then state or local general relief or general assistance, and then institutionalization for long-term care. So if someone was, hospitalized for an extensive period, then this could be something that would render a finding of inadmissibility based on public charge. And now the rule has expanded those programs to also include Medicaid, or in California, it's Medi-Cal, the Supplemental Nutrition Assistance Program, so that's SNAP or food stamps, Section 8 Housing Choice Voucher Program, Section 8 project-based rental assistance also now is included in the list of programs that will negatively affect someone under public charge, and then public housing. And so the list of programs has expanded pretty substantially. And so receipt of any of these benefits could be a big problem for someone who's applying for their green card, an immigrant visa, or a visa abroad. And then also with that saying that if anyone has received any of these benefits, then it doesn't necessarily mean that they will automatically be deemed inadmissible under public charge, but it definitely, should raise the red flag that they should consult with an attorney about whether or not they can apply at this time, or what they should be doing to better prepare their applications to be able to apply for these benefits in the future. And then something that's important to note is that if an individual, if they're not eligible to apply for a green card now or in the near future, then there may not be a reason for them to give up the benefits that they're, relying on and that their children are relying on this at this time. Again, the receipt, simply having received any of these benefits is not an automatic disqualifier. It will not automatically render someone inadmissible. And so if the well-being and safety of a family depends on receiving any of these benefits, then if they're not eligible to apply for a lawful permanent residency at this time, then maybe it's not in their best interest to discontinue using these programs. And then also, for the safety and security of an individual, then what we're asking service providers to make note of is it's not a good idea to refer the applicants or refer the people who are consulting with them or asking questions of them to refer them to USCIS. We had a situation in which someone contacted us and said, oh, I'm at the USCIS office and I'm trying to get in so that I can ask an officer whether or not the receipt of benefits or my receipt of specific benefits will disqualify me. We don't want to be referring folks to immigration or to Immigration Customs Enforcement, which at least in Santa Ana, in the city in which we practice or which U.S. Immigration Law Group is found, ICE is in the same building as USCIS, and it's true in many places. And so we would hate for someone to be referred to USCIS to go ask these questions. They're not going to get the information that they need from an officer at CIS, if CIS even lets them in the building, because at this time, CIS is not receiving individuals who do not have an InfoPass appointment, and would hate for them to, somehow wander into ICE's office and then find themselves in immigration custody. And so I think at this time, the best source of information for anyone who's unclear about whether or not receipt of benefits may affect their immigration process, the best source of information would be an attorney or an organization who deals with immigration services, not USCIS or ICE or the Department of Homeland Security generally. Okay, and then so some people have asked, well, what are ways that we can, improve our prospects of approval for lawful permanent residency, or how can we tip the scale in our favor when it comes to the public charge test? And so if possible, applicants should place assets in their name and then definitely minimize their debt, including credit cards and loans if possible. They should, if they can, they should continue their education or register for ESL courses at a local community college or at a community center. They should obtain and keep licenses or certifications that demonstrate English proficiency or professional skills. And they should keep all records of employment and income. So for example, paycheck stubs, we talked about this a little bit earlier, not getting rid of any paycheck stubs, federal tax returns, bank statements, and then documents just related to their credit history, because these are becoming relevant, or these have become relevant. USCIS is now specifically requesting that applicants provide credit history reports. And then if possible, we recommend that individuals purchase private health insurance. This is not through the marketplace. This is not through the open enrollment period that starts in November. This is directly from insurance providers. So one example I'll give is, I know Kaiser does offer private insurance plans. They are not cheap. We know that they are pricey, but to the extent that the person is trying to establish that they are able to pay for medical services and not rely on Medicaid, then it might be, even if it's for a short-term period, it might be in their interest to purchase a private health insurance plan directly. Okay, and then other steps to take just related to immigration benefits generally. Be informed. So it's important for folks to stay informed about changes in the law and then consult with an attorney or, again, a BIA accredited representative to learn about what their options may be. Be prepared, gather documentation that will demonstrate eligibility, and that includes that list of documents that we discussed earlier, that includes government documents, passports, medical records, IEPs, etc. Have a plan. Take action now and ensure that you qualify. Ensure that enrolling in school or acquiring professional training will have a positive impact when it comes to this public charge assessment. And then also, we're just asking everyone, community members, to use their voice. Share this information. You're welcome to share this presentation with friends, family, colleagues, and community members. And then also contact your representative, your congressional representative. Voice your opinions to Congress, because ultimately, when we want to see changes in policy and changes in the law, we have to do this by mobilizing our representatives and informing them of what it is that their communities need. So with that, I thank everyone who is here today. It looks like we have 110 participants. And so this is just wonderful. It's a wonderful opportunity for U.S. Immigration Law Group and for immigration advocates generally to be able to share information with service providers and anyone who might be sharing this information with folks who need it. And then also, I guess also, I want to stress that, U.S. Immigration Law Group, we are here as a resource for anyone, for service providers, for potential applicants. We encourage you to visit our website. We have, now on our website, we have the availability to schedule an appointment with any of our attorneys. And then also know that this information will be uploaded to our website, this presentation that I'm just giving now, and then any past presentations and resources and information, including, for example, a child care plan. These kinds of documents are also available on our website. And so to the extent that you know anyone who might be interested or who might need this information or these resources, please direct them to our website, because we will be publishing that there, as well as on our social media platforms, so Facebook, Instagram, Twitter. Our goal is to disseminate this information to everyone in our community, because you just never know who might need it. And so to the extent that we can be a resource to not only our local community, but to the broader community throughout California, that is what our goals are. And so thank you so much for this opportunity. It's been awesome to be able to work with Claudia and all of the partners who put this program together. So thank you.
Thank you so much, Monica. Thank you. And as we were listening to the presentation, a few questions came up, and so I'm going to leave that till the end of this presentation. We're going to go back and answer as many as we can.
Sure.
Like Monica mentioned, we do have more than 100 participants on the webinar. And with that said, if any of your coworkers were not able to log into the webinar, I do apologize. We did meet the limit of what Zoom is allowing us to do for this webinar, so I do apologize for that. However, Monica did mention this webinar is being recorded, and so afterwards I am going to be sending a follow-up email to all of those who registered. So if you can please communicate that with anybody who you know who was trying to log in but couldn't. I'm going to be sending out a link to a survey at the end, just a few questions for you to answer and give us feedback, as well as copies of any handouts that we talk about, resources, and the PowerPoint presentations, along with the link to this recorded webinar. So we're going to go ahead and continue with part number 2, but in the meantime, do use the chat box or the question and answer tool to post your questions, and then we'll go back to them afterwards in a bit. So we are going to be now talking about, when we are working with our families in the community, one of the things that come up is definitely stress. And just to add to it, we can mention COVID-19 and everything that has trickled down because of all the orders and restrictions of us just wanting to maintain and actually minimize the transmission of this virus. And so we're going to be talking about stress and how it affects daily life with the well-being and health. And I'm gonna go ahead and pass the mic over to Stephanie, Antonio, Miriam, and Nicole. You guys are on.
Hi, hello everyone. So my name is Stephanie. First off, I just want to thank Monica again really quick for that informative presentation. So now we're going to go ahead and transition into the second part of our webinar, which is going to focus on how we can continue to assist our families in this current political climate, as well as this terrible pandemic. I'm sure a lot of us had to make severe life adjustments as a result of it. And so our hope is that through this presentation, you all have a better idea of how to manage that stress for both yourselves and the people you work with, okay? So just to give everyone a quick overview of what we're gonna be going over, I think Claudia, do you have control of the PowerPoint? Okay, so just to give everyone, like I said, a quick overview of what we're going to be going in this presentation, we're going to be hitting on stress in the contents of immigration status, followed by, what stress is, and then we're going to identify specific stressors related to the immigrant population, followed by what stress may look like for individuals, and then the impact of that it has on families, and then next we're going to be going into a brief discussion of self-care methods and evidence-based practices that we can use with the people we work with, as well as for yourselves. And finally, we'll be giving you all a list of community resources that can be used, that can be given to clients if what they need is further professional help. All right, so just as the law group explained, we're living in a country where laws are constantly changing. And with the heightened enforcement activities imposed by Trump, this really has caused a lot of fear and uncertainty for both undocumented and mixed status families. When we think about the undocumented individuals and families, we're talking about the fear of being stopped by police for questioning. We're also considering the fear of accessing resources and services because they think that the information that they're going to provide it to these places are going to be given over to federal agents. And then ICE might show up at their door. So that's fear that's specific to undocumented families. But when we're also considering mixed status families, so those that hold lawful status in this country, we're talking about like the concerns that they have in terms of, what if the next law that gets passed is going to impact their ability and their permission to remain in the US. So really taking together, what we're looking at is that there's now more than ever, due to the political climate and the administration, these individuals are experiencing really high levels of stress. So how do we help these families? Well, first, before we get to that, we have to know what stress is and what that looks like. So stress at its most basic definition is a physical and emotional response to demanding situations. And within this broader definition of stress, we're looking at categories, which include individual, interpersonal, and environmental categories. When we're talking about the individual category, we're looking at things such as illness, substance use, finances, language. I know particularly for the immigrant population, most of them come into this country not knowing English. And so that itself makes it difficult for them to communicate with others and the broader society. And also within the individual category, we have negative perceptions and attitude. So this sense of, not belonging, of being seen as an outsider, that's a stressor. Next, we have the interpersonal category. And within this category, we're looking at things such as personal tragedy, the death and loss of a loved one. Family pressures is including in this, and also relationship conflicts such as divorce and separations. I know that when I think of this category, particular for the immigrant population, I'm thinking about, deportation and separation. Deportation is something that definitely, it literally physically separates a family unit, and so that in itself, it has detrimental consequences. We can go into talking about, the mental health, the emotional, effects that it has on families. So that's definitely an interpersonal stressor. Next, we have the environmental category, which we're looking at employment, or lack thereof. We know that a lot of immigrants that come into this country have a hard time looking or finding for a stable job. Also, or even finding a job that's willing to pay the minimum wage. Relocation, the fact of having to physically move into a different country is also a stressor. Then we have discrimination and limited access to resources. Okay, so let's identify some specific stressors that are unique to the immigrant population. So the first one that we're looking at is called cultural or normative stressors, which typically originate from cultural differences between an immigrant's country of origin and their host society. So an example of this adaptive stressor is language. Touching back on the previous slide that I mentioned, when we're considering language, that difficulty, if they don't know English, it becomes difficult for them to really communicate with others and to communicate those needs and wants. Next, we have instrumental adaptive stressors, which relates to the immigrant's material quality of life. So this refers to tangible things such as housing, having access to transportation, and even basic needs such as food and clothing. All this is definitely, if this population does not have access to us, it definitely impacts, their overall well-being and functioning. The third type of adaptive stressor that's unique to this population are social stressors, which includes immigrants' interactions and relationships with his or her social environments. So when I think of this, I think about the concept of person and environment. I know that as social workers, that's something that our profession is unique for looking into. We take this holistic approach, not only considering individual factors, but also the environment. And as we know, a person's individual interactions with the larger systems, whether that include their schools, their communities, their neighborhoods, those one-on-one interactions have an overall impact on their well-being and functioning. Especially when it comes to discrimination. Unfortunately, we live in a country where immigrants are frowned down upon, and there's this misconception that they're here to take away jobs, that they're criminals, and so that definitely has an impact on every immigrant individual. Next, we have family stressors, which refer to changes in the family unit as a result of migration. So again, going back to that interpersonal category and talking about the family unit and what happens when deportation becomes a reality, that's a stressor. And then finally, we have emotional stressors, which include uncertainty and anxiety about the future. So this actually leads me into the next slide when we're talking about what stress looks like. So some of the symptoms of stress, we all experience stress differently. However, research has proven that there are common symptoms of stress. And these include physical, emotional, and behavioral symptoms of stress. Under the physical category, we're looking at, people who are under stress may experience fatigue, sleep difficulties, stomach pain, and indigestion. I know that for me personally, when I'm really stressed about something, I definitely feel it. I start getting stomach aches and stomach cramps. So those are examples of physical symptoms that people might manifest. Next, we have emotional symptoms of stress, which include things like loss of motivation, increased irritability, and anxiety and depression. Coming into this new country as a newcomer can definitely lead to signs of depression, especially if they lack that support system and, they're having a hard time finding jobs. All these things, this feeling of not belonging with the mainstream society can definitely lead to depression and anxiety. And finally, we have the behavioral symptoms, which refer to as we all know, thoughts and emotions influence our behavior. And as such, when these symptoms are not addressed in a timely manner, a lot of our clients and the people that we work with it can lead to unhealthy eating patterns, such as anorexia or bulimia. People could go into using drugs and alcohol as means of coping, and even social withdrawal. So altogether, you know, this is really what we really need to be aware of this, of the symptoms of stress, so that we're able to help people when needed. Okay, so with that, I'm going to go ahead and turn it over to my colleague Tony to talk about the types of stress in terms of life events.
All right, hello everybody again. So I'm going to be defining the type of stressors that we could be experiencing. There's a lot of ways you could categorize stressors, but I'll be using the illness management and recovery model, IMR for short. This model has a curriculum that's provided by SAMHSA. It's free on their website. The link is going to be provided down on the resource list. So you'll have access to that. A lot of great resources there. So the first type of stressor is called life event. Very practical. It's in the name as to what it is. Many of the times as social workers, we're going to be in contact with people when they have a life event occur, such as getting divorced, such as losing a job. Right now with this COVID-19, people are losing jobs. People are in need of resources. So definitely this is a big stressors that we'll encounter on a daily basis when working with our patients, clients. The next type of stressor is the daily hassles. These are the everyday stressors that we experience. And these are very easily overlooked by people because we live in a society where we're always on the go. We're always, we're expected to multitask and to perform at our best capacity possible. You know, that whole no gain, no pain model, whatever we use. So, you know, when I work with patients, they always talk about how, you know, they've always been used to doing that until finally it becomes too much and they're unable to handle all these type of stressors that they experience. So this model gives opportunity to individuals to look at what areas they could, not sure why it skipped. So it gives individuals an opportunity to assess in what areas they could minimize some of the stress. So in the curriculum, they'll have the opportunity to categorize what kind of stressors they have, see how many stressors they have in that category, and you as a provider and could work with them and collaborate in developing strategies to minimize certain stressors. Some of them may be really difficult to come up ideas with, but you know, being there present for them, being able to give them the opportunity, that open space for them to talk about the stressors is very crucial. So now we can go to the next one. Next. All right, so impact of stress. Why talk about stress? My colleague right here, Stephanie, was talking about some of the important symptoms that people are going to be experiencing. You're going to see these symptoms display to people's physical health, to their emotional well-being, and it could affect people's behaviors. If people are displaying these symptoms, such as like being irritable, being unable to focus, it's going to impair their daily activities, such as their school performance, such as their relationships with their family members, their work performance. It's going to have a very negative impact in those activities that they do. So then eventually, if we get into accumulation of those daily hassles, those life events, people experience burnout. And that's when they're unable to physically and emotionally contain their stress, and those consequences could look different for individuals. I work at an inpatient unit, or I intern at an inpatient unit, and individuals have talked about how they couldn't take it anymore. They couldn't take the stress. They needed a break from life, from social life, from their work life, from everything. So as providers, it is important to inform our clients of the importance of stress and how to manage it, because we don't want individuals to be hospitalized or to turn to other things such as drugs or any other negative consequences. So before we go into the strategies on how to cope with stress, the curriculum goes over a quick little check-in as to a little exercise right here where it gives them some ideas as to some coping strategies. Some of the individuals will talk about how they do already have a coping strategy, but they may rely just on one. So someone will say, oh yeah, I rely on talking to someone, but when I don't have someone to talk to, then I have no other strategy. So developing that toolbox for individuals to be able to encounter those stressors that once expected or unexpected is really important. So individuals really find this beneficial to assess what their coping strategies are. So now we are going to get into some of the coping strategies. We have here Miriam, passing over. Thank you.
Hello, thank you everybody for being here. Thank you everybody for being here. My name is Miriam. We are talking about interventions today. The power of choice and notions. Self-awareness or self-talk. It is your self-talk positive or negative? What are you saying to yourself? Does it reason and empower you or increase your feelings or powerlessness? It is important to be aware of this. Also, awareness of physical and body experience. As Stephanie mentioned and analyzed before, we need to be aware of what happened in our body. Where do you usually carry on your stress? Do you get headaches, tightness in necks and shoulders? Are you aware of the signals your body is sending to you? Let's talk about awareness of emotions. What feeling are you most aware of when you are stressed? Do you have difficulty getting up in the morning and coming into work? How are you doing right now that we are in this situation in quarantine? Are you easy to adjust to this new environment? Are you most of us are working from our homes, so it is important to have that space to us too. Awareness of effects for one's actions. When you're under stress, how do you behave? More moody, isolated? Do others feel positive after they have interacted with you? Are they clear about your needs? Let's change the slides. Thank you. This is most of the points when we gotta stress our muscles tense on that certain points right there. And our shoulders, our legs, our arms. So right now, most of us are under these circumstances. Let's do a little, just quick an exercise. Let's close your eyes. Deep breathing. Become aware of your respiration. Sit in a comfortable, upright position. Take a big breath. Slowly begin to breathe in through the nose to the count of 8. Breathe slowly as deeply as possible. Notice your abdomen rise and fall. Feel your legs. Feel your chest. Feel your arms. Feel your neck. Continue breathing as slowly and deeply as possible. Work toward the goal of a one breath every 15 seconds. Let's feel your arms again. Now open your eyes. Next slide. There is another self-care social distancing we want to tell you about it. This National Counseling Association tell us to eat healthy, exercise, practice relaxation therapy, and be kind to yourself. Now that we are done this quick exercise and notice how our body is, take aware of that. Let me introduce Nicole. She will continue talking about the managing stress.
Hi, can everyone hear me? So hi again, my name is Nicole, and I'm going to be talking about, just briefly, I'm going to touch on 5 points on managing stress within families. So I'm going to start off with a little statistics. According to the American Psychological Association, 73% of parents reported family responsibility as one significant cause of stress. However, 2/3 of parents stated that their stress did not impact their children. However, studies show that only 14% of children reported that their parents' stress did not impact them. So it's actually a very low percentage, which shows that stress within parents really does spill over to their children. So now I'm going to get on touch bases on the 5 points. So one, it states evaluate yourself as far as parents. So everyone pretty much kind of know the social learning theory. We learn about that in social work. So the social learning theory just states that new behaviors can be acquired by observing and imitating others. So oftentimes if children see negative behaviors, they begin to imitate those behaviors. So modeling is very important. And it's important to model healthy behaviors so that children can lead a more healthy lifestyle. Also discuss. So if parents see their children looking worried, sad, concerned, it's important to have those regular conversations with them. Ask them what's going on, you know, create an environment where parents can promote open communication, because if you don't, how can those problems actually be worked out if parents aren't, you know, effectively communicating with their children? So it's good to get out there, ask those questions, kind of probe, and then just trying to find different ways to actually open up a discussion. Also creating a healthy environment. So we have control over our home life. So a lot of times our home and social environment can influence behaviors that lead to stress. So altering your environment can help alleviate stress. Maybe cleaning a room, clean out the backyard, cleaning out the kids' room. Studies have shown that, you know, a positive space, clean space, have alleviated stress for individuals and families. And then focus on yourself. So a lot of times parents, their main goal is to take care of their children, be that provider. However, a lot of times we have to take care of ourselves first. So mentally, physically, emotionally, parents need to take care of themselves, and then they can be that provider for their children. A lot of time parents are stressed about other things, and if they're not working on themselves first, how can they, you know, be that good parent to their children? So it's good that parents get enough sleep, they work on, you know, physically exercising. And I know things are easier said than done, but in social work, we really learned that, you know, self-care is very important, and especially during a time like this with the whole pandemic, just taking care of yourself so you can be, that better parent, or, just better to your children if you're actually doing well. And then change one habit at a time, which is my last point. So oftentimes we inspire to make these great, grand changes. And we're already handling many responsibilities, and we want to change everything at once. So it makes it really difficult if we're trying to change 10 things all at one time. So just making small and minimal changes, studies have shown that it has been a much better experience and a better outcome when trying to make small changes, because it can be very overwhelming trying to change multiple things at once. So yeah, that's just the 5 points that I'm briefly going to talk about. The next slide is just a brief snapshot of community resources that my group and I have provided. But as Claudia mentioned before, we're going to send you, after the presentation, we're going to send the actual whole list of resources that have been provided. But this is just a little quick snapshot of the ones that we decided to show you right now. But there's tons of more that will be available to you. And then the next one will be, so this concludes our presentation for the wellness. I would love for you guys, if you can, to complete our survey. I'm actually gonna put these in the chat section. I'm gonna put the link. So some people stated that they were unable to click on it. you should be able to click on it and it takes you to the website. If not, just copy the URL and put it in your little toolbar. I couldn't think of the name. Put it in the little toolbar, because some people are saying that they can click on it and some people are saying that they can't. But that really completes the survey. We're going to open up for Q&A. I'm going to give it back to Claudia. But again, I really do thank everyone. We have 105 participants. I really appreciate each and every one of you to take time out of your day to join us in this webinar, and we really do appreciate it. Thank you.
Thank you, Nicole. Thank you, everyone. Thank you again for all of your participation, for all of you that participated in this webinar. So one of the things that I do want to highlight as well is that right now, many of us as service providers, we are open as an essential service. And so that means that even though we're open, we need to limit the way that we provide services. Many of us are transitioning into telehealth or conferencing mode, connections only through phone right now, and that in itself can be a challenge. So when working with families, please remember to be patient as a provider, think outside the box as well, continue reaching out to each other. One of the things that we have been experiencing here through the Mini Street Family Resource Center is families are reaching out, and even though they are reaching out, the information that they do have is either limited or is incorrect. And so one of the recommendations that I have in terms of when working with our families is us as providers, informing ourselves of what is it that's going on out in the community. What are the most recent and updated orders that either your city that you service it has been putting out. Remember, not all of our families have access to the internet at home. And so part of the resources are going to include some links and information about how to help families get access or temporary access to the internet, which right now has become a vital tool for everybody to keep in communication, as well as reaching out to families who you've been working with prior, but if you do have the capability of reaching out to what we call closed cases, do so. Earlier last week, I was part of a webinar, and they really talked about being proactive at this time and reaching out to families. So if you already have and you have the capability of doing so, taking advantage of that. I understand that many of you don't have access to reaching out to closed cases, and that is okay. But for those of you who have access to reach out, just a little quick hello, how are you? How is this affecting you? Is really important, and it goes a long way. And we are a testament here at Mini Street. We've been able to do that. So we've reached the end of this webinar. It is 2:30, 2:31 at this point, but I am going to take a few extra minutes to go back to the questions that have been posted. And so one of the questions is for Monica.
Yeah.
Two questions are for Monica. One of them, it says for public charge, since it starts February 2020, if the individual terminates benefits now, would this make them eligible? Even if they have, benefit prior to February, for example, if they benefited, in this case, they have several clients that have had Medi-Cal for a long time. So
yes. Sorry. So I think that, it's a great question. I think it all goes back to whether or not the applicant or the person who's receiving the benefits, because, okay, so the direct answer to that is, the fact that they received benefits will have some impact. What that impact is depends on, sort of how that balancing test plays out. I think that if someone has terminated their benefits and they're no longer using them, does that suddenly make them eligible, or does it have a positive impact? It all really just depends on that balancing test that we talked about. So I guess, if they're no longer using Medicaid or Medi-Cal, it's going to be it's going to be considered positively, most likely. but it's hard for me to just give a blanket, a blanket response to that question, because this is such a case-specific analysis that's, dependent on not only, whether or not the applicant for the immigration benefit received Medi-Cal, but, like just generally what other benefits might they have requested. It's also, again, we're looking at all of those factors that we mentioned. It's the immigration adjudicators are going to be looking at their age, their employability, whether or not they have, an employment history, whether or not, if they had Medi-Cal, but were they using the Medi-Cal right? So I know like there's plenty of people who have Medi-Cal because they might have a health emergency, but they're not actively using it. Or were they actively receiving, ongoing long-term treatment as Medi-Cal recipients? I don't know. So again, I think that anyone who has received Medi-Cal in the past and who is contemplating the possibility of applying for adjustment of status, they definitely need to talk to an immigration lawyer to see or to assess how their receipt of that Medi-Cal could impact them. But if someone is currently, receiving Medi-Cal and they're receiving it for life-saving treatment, I would never tell them to stop. I would never tell them to cease receiving those benefits if it's life or death, because in my opinion, life trumps a green card, right? I think necessary medical treatment is going to always, in my opinion, have priority over applying for adjustment of status if, in the future something can be, or measures can be taken to later secure that green card. So I would never, and I don't think anyone in our firm would ever encourage someone to cease benefits that they require for their health and for their wellness. But if they have stopped using Medi-Cal, again, it's all going to come down to how that assessment, how that balancing test plays out. And so again, they need to consult with an immigration attorney to understand how it all plays out in the end.
Thank you, Monica.
Of course.
The second question that I have here is Regional Center of Orange County, the services that they provide possibly affect public charge for an individual? This has been a question for many families.
Okay, I think it depends on who is receiving those benefits. So if it's, if there's a potential applicant for lawful permanent residency or visas, as we discussed, who have a child in the home, or someone in the household who's receiving those benefits through the regional center, it's going to ultimately come into play when that balancing test takes place. But the sheer fact that someone in the household is receiving benefits from the regional center does not disqualify someone from seeking the green card, or it's not going to automatically make them inadmissible. So I know that this may not be the most helpful or informative response, but again, it's going to come back to assessing the totality of circumstances and consulting with someone who can help better understand how that balancing test is going to play out for a finding of public charge. But anyone who is going to apply for residency who has a child or a relative in the household who is receiving benefits, that's not going to be an automatic disqualifier for them, and they should know that.
Thank you, Monica. There was a few questions about handouts that we are going to be sharing with all of you afterwards regarding, are these handouts for parents to educate them regarding stress and COVID-19 and also mental health services in general? And the answer is yes. So what you're going to find in that document is links to various organizations that have put these wonderful resources together that we can share with our clients and families that we work with. So that is coming up, and it is part of what you're going to be getting after the webinar. A few more questions. If you can share, Monica, what are 2 places that people can check to see if an attorney sort of has all the qualifying factors to provide, honest services?
Sure. So definitely the state bar. So one of the tricky things about immigration law is because it's a federal It's a federal practice. That means that there are attorneys who can practice immigration law in California who perhaps are licensed in a different state. Could be Nevada, it could be New York. And so, I mean, I think the first order of business would be to ask the attorney or to find out, maybe investigate online what state they are licensed in. And so you can always check an attorney's profile on the on the state bar website in which they are admitted to see if there has ever been any kind of negative action taken against them. That's probably the most reliable source of information. And then otherwise, I mean, I know it's kind of weird, but we're living in this age of information technology, and Google is, you know, usually the first resource or the first place that people, you know, turn to find information. And in this circumstance as well, if you're trying to find out whether or not an immigration attorney or an attorney in general is has any kind of sort of maybe like negative action taken against them, you should be able to find that just by doing an online search of that attorney's information. And then, you know, these aren't the most reliable sources, but I mean, you can derive a lot of information from, you know, Yelp and those types of sources. But in terms of state sanctioned sources, it would be the state bar website in any, you know, in the state that the attorney is licensed in. Yeah, that's probably going to be the best source of information.
Okay, thank you, Monica. So
Sure.
I think those are all the questions that I see. Do any of you see any other questions, panelists?
I think there was one, sorry, this is Monica again. I think there was one other question, and it was about whether or not someone who is receiving Pru-Call Medi-Cal would be negatively impacted under the new public charge test. And my response to that is going to be that, well, so Pru-Call Medi-Cal is Medi-Cal available to folks who are residing in the permanently residing in the United States under color of law. And so, you know, assuming that they are within a class of applicant who is allowed to receive those benefits. So, for example, applicants for petitions under the Violence Against Women's Act or asylum, they're able to request certain benefits without worrying about or without consequence. And so, my response is, if they have Pru-Call Medi-Cal, they're probably okay. But regardless, I would always just have them consult and make sure, because I mean, not everyone knows what Pru-Call Medi-Cal is or understands what the program is. And so if they inadvertently, you know, obtained coverage under Pru-Call Medi-Cal, they would want to still consult and assess whether or not receipt of that coverage or that benefit could impact them.
Yes, thank you. Thank you. There was one more that just came in, and it says, at this difficult moment for families that are not working and are undocumented, receiving food from churches and other organizations where they request to show ID, could this be a risk or can be a part of public charge? That's
a good question. That's a really great question. So folks who are receiving food from food banks should not be impacted by the public charge rule. It's only if they're receiving food stamps or SNAP. But if the food bank is requiring you to show ID, that might be there might be an internal reason for why they're requesting that identification. I don't think that, as long as they're not asking for, well, I mean, if they're not asking for like an immigration number, I don't think it's going to have any consequence in terms of public charge. I think that it's probably an internal reason that they're asking for that ID. But requesting food, obtaining food through a food bank is perfectly fine and will not have a negative impact in terms of public charge. And also, folks who receive medical attention through clinics who are offering low-cost medical services through a state-funded program also should not be concerned that receiving those medical services will negatively impact them under public charge.
Thank you. And I think those are all the questions that I see posted. There was another. I think that those are all the questions. Again, thank you so much to everybody. Thank you to all of the Cal State Long Beach students, great team. And it was a pleasure working with you all. as well as the team from the U.S. Immigration Law Group, Monica, Senia. Thank you so much for all the work that you do and all the great information. And for everybody that is still remaining on the call, thank you so much. We're going to go ahead and end this webinar. Have a great afternoon.
Thank you.
Bye-bye.
Thank you.